Franchise operation in a simplified nutshell. This section represents a simplified description of how franchises operate that is useful to the common man and as a conversation piece at social events. To fully understand how franchises work, one must understand the nature of property from a legal perspective. Below is a definition. Property, that which is peculiar to or proper to any person, that which belongs exclusively to one, in the strict legal sense, an aggregate of rights which are guaranteed and protected by the government. The term is said to extend to every species of valuable right and interest, more specifically, ownership, the unrestricted and exclusive right to a thing, the right to dispose of a thing in every legal way, to possess it, to use it, and to exclude everyone else from interfering with it. That dominion or indefinite right of use or disposition which one may lawfully exercise over peculiar things or subjects. The exclusive right of possessing, enjoying, and disposing of a thing, the highest right a man can have to anything, being used to refer to that right which one has to lands or tenements, goods or chattel, which no way depends on another man's courtesy. The word is also commonly used to denote everything which is the subject of ownership, corporeal or incorporeal, tangible or intangible, visible or invisible, real or personal, everything that has an exchangeable value or which goes to make up wealth or estate. It extends to every species of valuable right and interest and includes real and personal property, easements, franchises, and incorporeal hereditaments, and includes every invasion of one's private property rights by actionable wrong. Property embraces everything which is or may not be the subject of ownership, whether a legal ownership or whether beneficial, or a private ownership. Term includes not only ownership and possession, but also the right of use and enjoyment for lawful purposes. Property within constitutional protection denotes group of rights inheriting in citizens in relation to a physical thing as right to possess, use, and dispose of it. Goodwill is property, as is an insurance policy and right incident thereto, including a right to the proceeds. Criminal Code. Property means anything of value, including real estate, tangible and intangible personal property, contract rights, choses in action, and other interests in or claims to wealth, admission or transportation tickets, captured or domestic animals, food and drink, electric or other power. Oh, interesting. All right. The idea of owning property carries with it the right to exclude all others from using said property and the right to control how property is used by others in every particular. The right to control how people use property is how franchises and trusts are created. In fact, one's right to control their property, who uses it, and how they use it is defensible in court by the owner as a matter of equity. When one takes Fed money, which is property, it always comes with regulatory strings attached. Well, they are not so much as strings, but rather they are massive sized chain links, linking the Fed benefit recipient to the U.S. government in a way that always requires the surrender by the citizen benefits recipient of some right. Here is how a book on the common law describes the method by which distributing government property called benefits can be used to control the recipient. How then are purely equitable obligations created? For the most part, either by the acts of third persons or by equity alone. But how can one person impose an obligation upon another? By giving property to the latter of the terms of his assuming an obligation in respect to it, At law, there is only one two means by which the object of the donor could be at all accomplished, consistently with the entire ownership of the property passing to the donee, namely, first by imposing a real obligation upon the property, secondly, by subjecting the title of the donee to a condition subsequent. The first of these the law does not permit, the second is entirely inadequate. Equity, however, can secure most of the objects of the donor and yet avoid the mischiefs of real obligations by imposing upon the donee and upon all persons to whom the property shall afterwards come without value or with notice a personal obligation with respect to the property, and accordingly, this is what equity does. It is in this way that all trusts are created and all equitable charges made, i.e., equitable hypothecations or liens created by trustators in their wills. In this way, also, most trusts are created by acts inter vivos, except in those cases in which the trustee incurs a legal as well as the equitable obligation. In short, as property is the subject of every equitable obligation, so the owner of property is the only person whose act or acts can be the means of creating an obligation in respect to that property. Moreover, the owner of property can create an obligation in respect to it in only two ways. First, by incurring the obligation himself, in which cases he is commonly also incurs a legal obligation. Secondly, by imposing the obligation upon some third person, and this he does in the way just explained. Readings on the history and system of the common law. All right. The Supreme Court describes the above process as following. When Sir Matthew Hale and the sages of the law in his day spoke of property as affected by a public interest in ceasing from that cause to be juris privatis solely, that is, ceasing to be held merely in private right, they refer to 1. Property dedicated by the owner to public uses, or 2. To property the use of which was granted by the government, e.g., social card, or 3. In connection with which special privileges were conferred, licenses. Unless the property was thus dedicated by one of the above three mechanisms, or some right bestowed by the government was held with the property, either by specific grant or by prescription of so long a time as to imply a grant originally, the property was not affected by any public interest so as to be taken out of the category of property held in private right. The title of the donee, the Roscoe pound, is referred to above. In the case of government franchises, for instance, is taxpayer and or citizen. The following maxims of law implement the above principle of equity. Conjus este commodium injus debata hasta commodum. He who receives the benefit should also bear the disadvantage. Que santin condom instar debanta hasta nos. He who deprives a benefit from a thing ought to feel the disadvantages attending it. Maxims of law. The principle that borrowing someone else's property makes the borrower the servant of the lender is also biblical in origin. Keep in mind that the thing borrowed need not be money and can be any kind of property from a legal perspective. The rich rules over the poor, and the borrower is servant to the lender. What kind of government property can be loaned to you that might impose an obligation upon you as the donee? How about any of the following, all of which are treated as government property and not private property? Receipt or use of any of the following types of property creates a prima facie presumption that you are a public officer donee, exercising agency on behalf of the government, which agency is on the other half of the mutual consideration involved in the implied contract regulating the use of the property. 1. Any kind of status you claim to which legal rights attach under a franchise. Remember, all rights are property. This includes taxpayer, IRC, trade or business franchise, citizen or resident, civil law protection franchise, driver, vehicle code of your state, spouse, family code of your state, which is a voluntary franchise, a social card. 20 Code Federal Regulations 422-103D says the card and the number belongs to the U.S. government. A taxpayer identification number. 10 Issued under the authority of 26 U.S. Code 6109. All taxpayers are public officers in the U.S. government. Per 26 CFR 301-61091. Use of the number provides prima facie evidence that the user is engaged in official government business called a trade or a business, which is defined in 26 U.S. Code 7701826 as the function of a public office in the U.S. and not state government. Any kind of license. Most licenses say on the back or in the statutes regulating them that they are property of the government and must be returned upon request. This includes driver's license, contracting license. A USA passport. The passport indicates on page 6, note 2, that it is property of the U.S. government and must be returned upon request. So does 22 CFR 517. Any kind of government ID, including state resident IDs, nearly all such IDs say they belong to the government. This includes common access cards, CACs, used in the U.S. military. A vehicle license plate, attaching it to the car makes a portion of the vehicle public property. That part. Stock in a public corporation. All stockholders in corporations are regarded by the courts as government contractors. The court held that the first company's charter was a contract between it and the state within the protection of the Constitution of the United States, and that the charter to the last company was therefore null and void. Mr. Justice Davis delivered the opinion of the court, said that if anything was settled by an unbroken chain of decisions in the Fed courts, it was that an act of incorporation was a contract between the state and the stockholders, a departure from which now would involve dangers to society that cannot be foreseen, would shock the sense of justice of the country, unhinge its business interests, and weakens, if not destroy, that respect which has always been felt for the judicial department of the government. Essentially, Uncle Sam is in the property renting business. He had the monopoly part. And the above type of property are the thing being rented. We have repeatedly held that the Fed government may impose appropriate conditions on the use of Fed property or privilege and may require that state instrumentalities comply with conditions that are reasonably related to the Fed interest in particular national projects or programs. A requirement that states, like all other users, pay a portion of the cost of the benefits they enjoy from Fed programs is surely permissible, since it is closely related to the Fed interest and recovering costs from those who benefit, and says it affects no greater interference with state sovereignty than do the restrictions which this court has approved. Wow, that is wild. Once they lend you a government property essentially as a bribe, you consent to be treated as a de facto public officer in the government. A public officer is, after all, legally defined as someone who is in charge of the property of the public, recipient and temporary custody of the valuable property of the public, therefore constitutes your employment consideration to act as a public officer. Whew. Public officer office. The right, authority, and duty created and conferred by law by which for a given period, either fixed by law or enduring at the pleasure of the creating power, an individual is invested with some portion of the sovereign functions of government for the benefit of the public. An agency for the state, the duties of which involved in their performance the exercise of some portion of the sovereign power, either great or small, where by virtue of law a person is clothed not as an incidental or transient authority, but for such time as a denote duration and constituents with independent power to control the property of the public, or with public functions to be exercised in the supposed interest of the people, the service to be compensated by a stated yearly salary, uh, and the occupant having a designation or title. The position so created is a public office. Why do they use property as the means to effect or create the franchise? The reason is because they have jurisdiction over their property wherever it is situated, including within states of the Union. Your all capital letter name, wherever. The Constitution permits Congress to dispose of and to make all needful rules and regulations respecting the territory or other property belonging to the United States. This power applies as well to territory belonging to the United States within the states as beyond them. It comprehends all the public domain, whatever it may be. The argument is that the power to make all needful rules and regulations is a power of legislation, a full legislative power. That is, includes all subjects of legislation in the territory and is without any limitations, except the positive prohibitions which affect all of the powers of Congress. Congress may then regulate or prohibit slavery upon the public domain within the new states, and such a prohibition would permanently affect the capacity of a slave whose master might carry him to it. And why not? Because no power has been conferred on Congress. This is a conclusion universally admitted. But the power to make rules and regulations respecting the territory is not restrained by state lines, nor are there any constitutional prohibitions upon its exercise in the domain of the United States within the states. And whatever rules and regulations representing territory Congress may constitutionally make are supreme and are not dependent on the status of the territory. If they didn't use the lending of their property to reach you, they would otherwise not have civil jurisdiction over those domiciled in a legislatively but not constitutionally foreign state, such as the constitutional state of the Union, through their civil law. Since all law is prima facie territorial, and they don't own and don't have civil jurisdiction over constitutional states of the Union. The canon of construction, which teaches that legislation of Congress unless a contrary intent appears, is meant to apply only within the territorial jurisdiction of the United States. It is a valid approach whereby unexpressed congressional intent may be ascertained. It is based on the assumption that Congress is primarily concerned with domestic conditions. The laws of Congress in respect to those matters outside of constitutionally delegated powers do not extend into the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. There is a canon of legislative construction which teaches Congress that unless any contrary intent appears, legislation is meant to apply only within the territorial jurisdiction of the United States. Ultimately, however, what your corrupted public servants are doing is both criminal and illegal. None of the franchises they administer expressly authorize the creation of any public offices in the government, but rather add benefits to existing public offices. If they abuse public funds and programs to bribe otherwise private people to accept the duties of a public office, the U.S. Code says this is a serious crime. Title 18, Part 1, Chapter 11, 210. Offer to procure appointive public office. Whoever pays or offers or promises any money or thing of value to any person, firm, or corporation in consideration of the use or promise to use any influence to procure any appointive office or place under the United States for any person shall be fined under this title or imprisoned not more than 1 year or both. Title 18, Part 1, Chapter 11 to 11, Acceptance or Solicitation to obtain appointive public office. Whoever solicits or receives either as a political contribution or for personal annulments any money or thing of value in consideration of the promise of support or use of influence in obtaining for any person any appointed office or place under the United States shall be fined under this title or imprisoned no more than 1 year or both. Whoever solicits or receives anything of value in consideration of aiding a person to obtain employment under the United States, either by referring his name to an executive department or agency of the United States, or by requiring the payment of a fee because such person has secured such employment, shall be fined under this title or imprisoned no more than 1 year or both. This section shall not only apply to such services rendered by an employment agency pursuant to the written request of an executive department or agency of the United States. If you collude with your criminal public servants in this fraud by accepting the bribe and carry on the charade of pretending to be a public officer, you too become a criminal who is impersonating a public officer. You also become hated in the Lord's eyes because you are simultaneously trying to serve two masters, meaning the Lord and Caesar. Title 18, Part 1, Chapter 40 through 912. Officer or employee of the United States. Whoever firstly assumes or pretends to be an officer or employee acting under the authority of the United States or any department, agency, or officer thereof and acts as such or in such pretended character, demands or obtains any money, paper, documents, or anything of value shall be fined under this title or imprisoned no more than 3 years or both. Ooh, 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 ooh. No one can serve two masters, for either he will hate the one and love the other, or else he will be loyal to the one and despise the other. You cannot serve the Lord and mammon, unrighteous gain, or any other false god. Everything they give you will always be a loan rather than a gift. Everything they give you will always have legal strings attached that makes the property they give you into a Trojan horse designed to destroy and enslave you. The proverb, beware of Greeks bearing gifts, definitely applies to everything the government does. Please keep these critical facts in mind as you try and decide whether you want you and your family to give the corrupted U.S. government the right to intrude into your personal health care. They're already doing that this year. Also, keep in mind that under the concept of equal protection, you can use the same tactic to entrap and prejudice the government and defend yourself from this tactic. Hence, is this principle of equity in action, as espoused by the U.S. Supreme Court in Philwell versus Wellnick. What the U.S. Supreme Court is describing is the basic principle for how franchises operate and how they are used to snare you. In a 6-3 decision that dealt with the 10% minority set aside issue, the court held the following. Congress has frequently employed the spending powers to further broaden policy objectives by conditioning recipient of Fed monies upon compliance by the recipient with Fed statutory and administrative directives. This court has repeatedly upheld against constitutional challenge the use of this technique to induce governments and private parties to cooperate voluntarily with Fed policy. When those who are unknowingly party to a franchise challenge the constitutionality or violation of due process resulting from the enforcement of the franchise provisions against them, here is how the U.S. Supreme Court has historically responded. We can hardly find a denial of due process in these circumstances, particularly since it is even doubtful that appellee's burdens under the program outweigh his benefits. It is hardly lack of due process for the government to regulate that which is subsidized. That is crazy. The key to the effect of the convenience of property is the nature of the funds or property conveyed by the government. If it was property of the government at the time it was conveyed, then it is subsidy and conveys right to the government. If, on the other hand, the property was someone else's property, temporarily loaned to the government under the franchise of the real owner, it ceases to be a subsidy and cannot convey any right to the government under its franchise because the government is not the rightful owner of the property. That is why everything that members of the ministry convey to the government is identified legally not as a gift but a loan on the following form. Section 6 establishes what we call an anti-franchise franchise, which reverses the relationship between the parties and makes all those who receive monies from the sender into officers and servants of the sender under franchise contracts. If you want to win at this game, you have to use all the same weapons and tactics as your enemy and insist furiously on complete equality of treatment and rights as the Constitution mandates. You can't do that until you have identified and fully understand how all of the weapons function. Here is yet more proof of why those who accept government benefits cannot assert their constitutional rights as a defense to challenge the statutes that regulate the benefit. The language below comes from the Brandeis Rules for the U.S. Supreme Court. The principle is invoked that one who accepts the benefit of a statute cannot be heard to question its constitutionality. They out here fucking shit up. What the court is saying in the above statute is that those who accept Fed benefits have no constitutional rights and have voluntarily surrendered all such rights. Thank you. Here's how franchises enslave and entrap you. Congress borrows money in your name like they were using your credit card from the private Fed Reserve Bank. Yo, this is fucked up. You and your descendants must pay this money back at interest. Oh, Lord. I sincerely believe that banking establishments are more dangerous than standing armies, and that the principle of spending money to be paid by posterity under the name of funding is but swindling futurely on a large scale. Man, Thomas Jefferson said that shit. Oh, hell to the no. Congress wants to further its broad policy objectives, like making America a socialist state under a unitary executive or invading another country for its natural resources. Yo, that is what we're seeing right now. So Congress offers private people and state and foreign governments bribes using the money borrowed, stolen in number 1 above, on condition that those private people and state and foreign government cooperate voluntarily with Fed policy, which is really just private business actively disguised to look like government business. 4. Fed policy is whatever Fed judges and other bureaucrats say it is. 5. Among the Fed policy you must comply with is for them to be able to lawfully and administratively take from you any amount of money they want to fund their program. This is done through false information return reporting, i.e., administrative levies that would otherwise be a constitutional tort, etc. 6. In short, once you accept the bribe, you change from being the boss of your public servants into their employee, officer, and chief whore. They turn the relationship upside down with trickery and words of art. 7. If you create your own franchise, we call it an anti-franchise franchise and call everything you pay them a privilege and use their own game rules against them. They will hypocritically and unlawfully apply different rules against themselves than they apply to you in violation of the requirement for equal protection. If they are going to defend the above method of acquiring rights, they have to defend your equal right to play the same rules with them and prohibit themselves from abusing sovereign immunity to make the game rules unequal. They call what you give to them a non-refundable gift in 31 U.S. Code 321D, and yet everything they give to you is a mere temporary loan that makes you their voluntary, uncompensated public officer. Yeah, that's a bunch of hypocrites, man. Notice the word voluntarily. The Fed government cannot coerce a state citizen, not domiciled on Fed land, and not taking money from King Congress. The only way the Fed government can make you a subject of itself and rule over you and tax you is by your consent in taking Fed benefits, bribes to entice you to agree to its jurisdiction. The Declaration of Independence requires the Fed Gov to get your consent in order to exercise its powers. Parents tell their children government instituted slavery using franchises. As long as you live in my house, you play by my rules. The Fed government says the Supreme Court agrees. As long as you take money from me, you play by my rules, ho. E.g., compulsory health care, compulsory flu injections, compulsory education for your children in government schools, Fed income tax, etc., not by constitutional rules. Now, 1. Are you a free, self-determining citizen of your state, or are you a subject of the Fed Gov? 2. Did you sign the Social Security application giving your consent for your newborn children to be subject of Fed bureaucrats and tyrants? We use the term state citizen in the same sense that the reader understands it. If you are a subject of the Fed government and have made your children subjects of the Fed government by writing them off as a privileged tax deduction, you a hoe, on a Fed tax return, the Supreme Court has held over and over that you cannot bring constitutional challenge against the Fed government in a federal courtroom. Yo, this is insane. Fed judges will dismiss you, and rightly so, for lack of standing. Bitch, this is crazy. These general rules are well settled. That the United States, when it creates rights in individuals against itself, a public right, which is a emphasis for a franchise to held the court disguise the nature of the transaction, is under no obligation to provide a remedy through the courts. Exactly. That where a statute creates a right and provides a special remedy, that remedy is exclusive. Still, the fact that the right and the remedy are thus intertwined might not, if the provision stood alone, requires U.S. to hold that the remedy expressly excludes the right of a review of the courts of claims, where the decision of the special tribunal involved no disputed question of fact, and the denial of compensation was rested wholly upon the construction of the act. Oh yeah, they said they can do whatever the fuck they want to us, man, and get away with that shit. Since the U.S. Constitution offers no remedy to statutory subjects and serfs of the Fed government when rights which state citizens have surrendered for a bribe are violated, what is it they actually celebrate on the 4th of July? Oh yeah, let's get it. By waving those Fed flags made in communist China. Thank you. Hairball. What is really going on in this house? Yo, this shit crazy. I ain't never read this book. This shit is fucking crazy, bro. What is really going on is that there is an invisible war being waged against our constitutional rights by people who are supposed to be serving and protecting you, but who have stealthily and invisibly transformed from protectors into predators, man. Damn. As a result of these helpful transformations, Americans are legally unaware that they are a conquered people. Whew, I'm getting passionate here. Let me go down. The conquerors are aliens from a legislatively foreign land called the District of Columbia who bribe you to put on chains and go not into a physical cage, but a legal cage called a franchise. Behold, I will make my words in your mouth fire, and this people wood, and it shall devour them. Behold, I will bring a nation in the District of Columbia, Washington, D.C., against you from afar. O house of Israel, says the Lord, it is a mighty nation. It is an ancient nation, a nation whose language, legalese, you do not know, nor can you understand what they say in their deceitful laws. Their quiver is like an open tomb. They are almighty, deceitful men, and they and the IRS, their henchmen, shall eat up your harvest and your bread, which your sons and daughters should eat. They shall eat up your flocks and your herds. They shall eat up your vines and your fig trees. They shall destroy your fortified cities and businesses and families in which you trust with the sword. This is the same thing that Jacob did to Esau, his brother, in the Bible, persuading him to give up his freedom and inheritance for a stinking bowl of pottage. Here is the way the Bible dictionary describes it, wherein taxes used to be called tribute in biblical times. Tribute. Tribute in the sense of an impost paid by one state to another, oh Lord, as a mark of subjugation is a common feature of international relationships in the biblical world. The tributary would be either a hostile state or an ally. Yo, that's fucking wild. Like deportation, what the fuck? Its purpose was to weaken a hostile state. Yo, they wildin' out here. Deportation aimed at depleting the manpower. The aim of tribute was probably twofold: to impoverish the subjugated state and at the same time to increase the conqueror's own revenue. Oh Lord, and to acquire commodities in short supply in his own country. As an instrument of administration, it was one of the simplest ever devised. The subjugated country could be made responsible for the payment of a yearly tribute. Its non-arrival would be taken as a sign of rebellion, and an expedition would then be sent to deal with the what the fuck? This was probably the reason for the attack recorded in Gen 14. That's wild. That's fucking wild, man. That's fucking wild, y'all. Yo. Yeah, it's time for a fucking rebellion. Fuck all that. Fuck all that. Your devious conquerors are doing and will continue to do everything in their power to keep you in their legal cage as their satanic sex slave, prisoner, and whore. Yeah, man. Yeah, man. This is the same whore that the Bible refers to as Babylon, the great harlot, in the book of Revelation. By sex, we mean commerce between you and a corrupted de facto government that loves money more than it loves your freedom. Black's laws defines commerce, in fact, as intercourse, and therefore sex in a figurative sense. Commerce, intercourse, by way of trade and traffic between different peoples or states and the citizens or inhabitants thereof, including not only the purchase, sale, and exchange of commodities, but also the instrumentalities, governments, and agencies by which it is promoted and the means of the applicants by which it is carried on. Black's Law, 6th edition, page 269. Here are the things your covetous conquerors have done and will continue to do to compel you at gunpoint to bend over and be a good little whore or be slapped silly with what the Constitution calls a bill of attainder for rattling your legal cage. 1. They will willfully lie to you in their publications with judicial impunity about what the law requires. 2. They will tempt you with socialist bribes called benefits. 3. They will rig their forms so that it is impossible to truthfully declare your status, leaving as the only option available statuses that connect you to consent to their franchises, even if you do not consent. 4. If you already ate the bait and signed up, they will falsely tell you that you aren't allowed to quit, meaning that you are a slave for life. 5. They will hide the form and procedures that can be used to quit the franchise by removing them from their website, but still making them available to people who specifically ask. 6. They will make false, prejudicial, and self-serving presumptions or determinations about your status that they are not allowed to do until after you expressly consent to give them that authority in writing, and they will do so in violation of due process of law. 7. They will deceive you with words of art. 8. They will publish false propaganda, encouraging third parties to file knowingly, falsely, and fraudulent reports about your status, such as information returns that constitute prima facie evidence of consent to participate in government franchises. Such reportings include I edit S Forms W2, 1042S, 1098, and 1099. 9. They will willfully refuse or omit to prosecute the fillers of false information returns, thus compelling you to unlawfully and criminally impersonate a public officer who is compelled to fill a position as a franchisee. It is called theft by omission and is also a criminal conspiracy against your constitutional rights. Both omissions and commissions that cause injury to you are crimes. They might even protect criminals filing these false reports instead of the victims. 10. They will disestablish all constitutional courts that could serve as a remedy against such abuses and replace them with statutory franchise courts that can't recognize or even rule on constitutional issues or rights. 11. They will use selective enforcement of the tax laws as a way to silence and punish those who expose their monumental scam. They don't need to torture you physically. All they have to do is destroy your ability to survive commercially, and it is as good as putting you in jail and subjugating you to physical torture. 12. They will remove the subject of law from the curricula in public schools so they can do all the above things. without you even realizing it is happening, so that you don't become alarmed as they tighten the bars of your cage. Welcome to the Matrix, Neo. Agent Smith with the IEDS is waiting for you in the next room.